Council, who represents Pakistan Bar Council. So they had sought full court, and there are two more CMAs, CMA 3166 and 3199. They had also sought full court. So these applications have become, in a way, allowed. Okay? So now we proceed to hear your contentions. The rest of you can take a seat. Khwaja Saab will first address, and then the others can address.
I'll hand it over to Mr. Siddiqui, sir, because he's, to be very honest, sir, at the time of the, when this was first heard by 8 judges, Mr. Siddiqui led the arguments. He's fully prepared, but I would like to say a few words.
Let's forget the past. Today is the first date of hearing.
I'll say a few words, and then I'll leave the floor to Mr. Siddiqui. I want to make it one thing very clear. When this Supreme Court Practice and Procedure Act came into force, or became in the form of a bill and later became an act, I read clauses 1 and 2 thereof. Your lords have this act in front of you?
I think one of the petitioners has filed it. It's CMA 5104. I don't know who is 5104. It's attached with it. Ji, please read it. Argue as you please.
By the end of your lordship,
which is the petition that you?
I will be starting from 6, sir, because 6 is the one when the orders have been passed. But may I also say?
No, you started with the Practice and Procedure Act. You wanted to read it.
I'll read it. Before I do that, there is an order dated 2nd of May.
Ajay sir,
we are forget about the past.
Because we are not, don't do this.
Okay, so I'll say, let's bury the past.
Don't bury it, it's past. You can't bury the past.
So, all right, for the time being,
argue as if you are arguing for the first
time.
Thank you.
Well, I do say
here. I may ask a question. Khwaja Saab, idhar dekhen. You have endorsed the sitting of the full court, which is fine, but I'm just wondering what will happen to Section 5 in the event if the law is upheld. There is a right of appeal that is provided under this law. In that case, then how do you visualize that right being exercised?
I was going to come to that. I'm very thankful to leadership, because if the full court is going to hear it, then I have no right of appeal.
But in the event, since we are hearing the vagaries of this law, what will happen to this right if a full court is now going to proceed with the matter?
In fact, when I go through the law, there are so many things.
वो अपनी जगह है ना जी. Let's just assume बहस हो जाएगी. Section 5 को फिर क्या होगा? Will Section 5 not be exercised by one party?
It says that an appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of Article 184 of the Constitution.
Khwaja Saab, if I may interject, you please proceed as you want to. Let's read the Act together. Whatever you want to comment about the Act, and please also address the query that has been addressed to you in your own manner as you wish. So let's start with the Act at least.
I would like to answer that when I'm going through this, because this is a...
So let's start reading the Act. You want to read the Act or you don't want to read the Act?
I will read the Act now.
Chal.
I'll start with Section 1. But first of all, let me say this one. I would just state this thing, that by the end of your honest tenure, if I'm still alive, I would have completed 50 years of practice in this honorable court.
Can you please read? No, let's not do that.
Let me say.
This is public time.
When I saw this act,
let's read it. When you saw it, we're not interested.
Well, see the Section 2 thereof.
Please read the whole Act.
I read it, sir. Whereas Article 191, I'm reading the preamble. 191 of the Constitution provides that subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the Supreme Court. Now, at present, there are the 1980 rules which govern the procedure here in the Supreme Court. Before that, there were the 1956 rules. The 1980 rules were on account of a judgment which came in 1979.
Sajjad Sahab, please focus.
Okay, I'm focusing myself.
We know the 1980 rules.
Background.
No, please don't. We don't. The country expects 57,000 cases to be decided. We would love to hear you, but let's focus on your petition. Now you have started reading, you started giving the history of 1980 rules. We know that. If you'll ask a question, please answer that, but proceed with your arguments.
I have said about this 1980 rules for the simple reason that if I read now section 2, it says...
Please continue, don't jump to section 2.
Right. And whereas article 10A is of the Constitution, mandated right to fair trial and due process. Article 4 of the Constitution guarantees treatment in accordance with law. Article 25 of the Constitution prohibits discriminatory treatment, and right of appeal is a universal fundamental principle of jurisprudence, and Islam guarantees right of appeal. Therefore, pursuant of Article 175(2), read with Article 191 of the Constitution, this law is being enacted. The court will see that there is no mention of item 55 of the federal legislative list as far as this preamble is concerned. It is silent. Because that is the basic, what can the parliament do? Parliament is not omnipotent. It has to go according to certain constitutional limitations. That principle of old principle that the parliament is supreme means that they are omnipotent, led by Dicey and influenced by Blackstone and Co. So we all agree that Parliament has limitations.
This law doesn't say that. Don't insert words which are not written there. Law doesn't say Parliament is omnipotent. Just restrict yourself to the act which you have challenged.
When I say this thing, that this very preamble does not mention.
It's noted. Read it on.
Okay. And whereas it is expedient to make a law providing for certain practice and procedures of the Supreme Court. It is hereby enacted as follows. This act shall be called the Supreme Court Practice and Procedure Act 2023, and it shall come into force at once. Constitution of benches, that the crucial question which arose. Every cause, appeal or matter before the Supreme Court shall be heard and disposed of by a bench constituted by the committee comprising the Chief Justice of Pakistan and two next most senior judges in order of seniority. Now, one of the 1980 rules, Order 11, read in this manner. Because if you have to correlate, it may be important to do that.
पहले अगर इस एक्ट को पढ़ लें हम ताकि हम सबको पता लग जाए कि इसमें क्या है क्या नहीं.
Sir, which rule were you referring
to? If you want to continue like this, we'll go ahead. Because my viewpoint is this, that this frame of these rules under Article 191 is the prerogative of the Supreme Court, sitting at the full court. When they framed the 1980 rules, the entire court sat together and in their wisdom, together they framed the rules. This abdication or this intrusion by the Parliament into the affairs of the Supreme Court prompted me to come forward and file this petition. Because I feel that every institution must remain within its own domain.
Khwaja Sahab, I'm here.
on this side.
It's right here.
I'm here on this side. If you could kindly formulate your exact legal proposition. What you are suggesting is that you do not have any objection to the untrammeled, unaccountable powers in one office? Is that your question?
My contention is this.
Are you supporting what has happened in the past?
I am supporting what happened in 1980, and I'm supporting...
So what is your legal proposition?
My legal proposition is this, that this power of forming the benches, etc., is the domain of the Supreme Court itself.
If this is your proposition...
I think you should read the law first, Khwaja Sahab, and then formulate the points.
Let us first formulate...
Act पढ़ लीजिए, उसके बाद
फिर एक-एक को
it is only 2 pages act. It is only...
Let me follow the Chief Justice.
Khwaja Sahab,
let me read the law, and then we make my submission.
If I may make your job easier, undoubtedly it's sometimes very difficult and disconcerting if questions...
I know it's very difficult to get an answer questions.
Zara sun lijiye, Hazur. If you are receiving a lot of questions from different sides, you don't even know who is asking the questions. If one of your associates jots the questions down, please don't respond to it. We let you argue it as you want to. Let me just finish. You read the act. You just point out, either you say this entire act is ultra vires a constitution. That's one contention. If there are certain particular portions of the act which you think are ultra vires a constitution, please, as you're arguing, point that, formulate the contention and move ahead. You don't need to respond to every query immediately. It will make your life very difficult because you won't even know where the question is coming from. One of your associates can take, and when you're done with your arguments, you can absorb the questions and respond. We will give you time to respond to the queries. Okay? Toba, please continue with the act.
Just can you take down the points and so that you can answer them. Second part of this section 2. Soon after commencement of this act, the committee constituted under subsection 1 shall hold its first meeting to determine its procedure, including the holding meetings and constitution of benches, provided that till such time the procedure is determined under this subsection, the meeting of the committee for the purposes of subsection 1 shall be convened by the Chief Justice or other 2 members of the committee as the case may be. The decisions of the committee shall be by majority. Now this is what the Parliament has enacted. And the provision which they have used is Article 191. At this stage, I would simply say this thing, that when myself and Imtiaz will be answering your question and promulgating, we would certainly refer to item 55 of the Federal Legislative List, which spells out whether the Parliament can make enactments relating to Supreme Court. If I may read 55 at this stage, it may be...
Argue as you want.
Well, all right. I'm just saying that your Lordship should note item 55 of the Federal Legislative List.
Let's read it together. You wanted to read it. Let's read it.
We'll read it together.
Khwaja Sahab, I think before going, I'm here, left side, your right side. Before going to this entry, if you want, you may read Article 191 of the Constitution. What it says.
191 also. In fact, I can start with Article 70, go on to 142, and then read 191 and go up to 55. Article 70 gives the power of legislation, and it is to the effect legislative procedure. And what it says is, a bill with respect to any matter in the Federal Legislative List may originate. I will skip that. I'll go straight on to sub-clause 4 of Article 70. In this article and the succeeding provisions of the Constitution, Federal Legislative List means the Federal Legislative List in the 4th schedule, sir. Then there is Article 141. Subject to the Constitution, Majlis and Shura Parliament may make laws, including the laws having extraterritorial operation for the whole or any part of Pakistan, and the Provincial Assembly may make laws for the province or any part thereof. 142. Subject to the Constitution, Majlis and Shura shall have exclusive powers to make laws with respect to any matter in the federal legislative list. Then I take your lordship to 191, which is to the effect subject to the Constitution, again, subject to the Constitution and law. It is the Supreme Court. The Supreme Court may make rules regulating the practice and procedure of the court. The crucial words here are that the power has been given to the Supreme Court to regulate its practice and procedure.
These powers are under the Constitution. Your right side. These powers are under the Constitution and the law.
Constitution and the law. I'll say also. I'll come to that also, because when I read 55, then it will be clearer.
Khaizab, if I may request my learned brother, I know it's very disconcerting, so many judges asking questions. So we will let you argue in your own way, and we will ask you questions. You don't respond, you just note it. And because then I know your chain of thought will...
Point is noted.
Chain of thought we don't want to break.
Constitution and law. Point is noted. Constitution and law. Point is noted of my lord that what will be my proposition, and also what Justice Mansoor Ali Shah has said, that how will I go and make my propositions and to say how this law is not obtainable. But may I read 55 registry?
Please do.
Because your lord may ask questions on that. 55 of the federal legislative list. It says jurisdiction and powers of all courts can be subject to the power of the Parliament under 142 and 74.
Just read it as is. Don't interpret it. Then you can interpret it.
Okay, I'll go along with that. Jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list, and to such extent as is